All right. So thank you for joining us for another workshop on behalf of the ICRR Business Center. We are an organization in partnership with the Chicago Minority Supplier Development Council. If you're not familiar with the council is positioned to help minority businesses who are interested in becoming certified to do business with large corporations to get the certification and then have the opportunities to have matchmaking events or networking events, opportunities to speak directly with the buyers of these organizations, and just positioning them to actually get those opportunities. Because getting certified is one thing, actually getting contract opportunities is another thing. So the council is all inclusive when it comes to helping minority businesses do business with large corporations. So again, this particular program, this workshop is brought to you on behalf of the Illinois Coronavirus Response and Relief Business Center. And our mission is to assist minority-owned businesses in urban and rural areas with understanding and taking advantage of resources and services that are made available by our local, state, and federal government agencies due to the impact of COVID-19. And so we're doing this through education and training, networking events, and we are bringing in subject matter experts like our speaker today, Lauren Morgan, to talk about areas such as finance, supply chain, organizational development, technology, sales, and legal. So today we are focused on some legal subject matter. So again, to introduce our speaker, we have Lauren Morgan. She is a business attorney. She specializes in contracts, business consulting and strategy, and entity setup. This presentation will be shared following the workshop. So you'll be able to click Lauren's direct link to her LinkedIn page. But if you're looking at it, this is her name on LinkedIn, so you can just search her and make sure you connect with her so that you have her as a resource. Maybe you don't need the services right now today, but if you are in business and you keep doing business, I guarantee you will run into a situation where you would want to have access to an attorney. And I personally use her services, so I can personally attest to what you'll be getting on the other end. So definitely connect with Lauren if you do not already have a business attorney. If you don't know me, my name is Christina Wynn. Again, I'm a consultant for the ICRR Business Center, and I'm also a business owner. I like to say that because when I bring in speakers and the different subject matter that we touch upon, I also am experiencing those same things as a business owner. So I'm learning as you're learning, and I want to make sure we keep bringing quality speakers in for you all to address the issues that you have. So if you find yourself looking for content that we have not covered or just needing some additional support, please make sure to reach out to me. My email address is here below, kwin@chicagomsdc.org. Just want to say thank you again. If you would like to get in contact with the ICRR Business Center in general or our director, Irma Lopez, please feel free to find us at the ICRR at Chicago MSDC email address. And then finally, as we transition into Lauren's presentation, I want to give you an opportunity to scan the QR code. This is our intake form. So to make sure you are connected to all the upcoming workshops we have a workshop almost every day in the month of May, and we are filling up our June calendar. We have a couple of in-person networking events that we are planning. So to make sure that you are a part of the correspondence and the first group of people to get that information, I encourage you to complete our intake form. So that is all that I have. I'm going to stop sharing my screen, and then I'm going to allow our speaker to take us away.
Awesome. Well, thanks again for having me today. I'm looking forward to part two, where we're going to do a little bit more of a deep dive into it. The presentation slides are going to be the same, but the topics that I pull off of it are going to be different as discussed on here today. So let me get that pulled up for you guys and we'll get started. All right. And so this down here. All right, so once again, I won't go into an introduction because we did all that good stuff yesterday. But my name is Lauren Morgan. I am the founder and attorney behind Activated Law. And today we are just doing a deep dive into, what we talked about yesterday, the pros and cons behind some of the entity types. We are also going to be talking about contracts as well as trademark and intellectual property that way, okay? So let's go. Excuse me. So we talked about this slide in depth yesterday. So we won't be starting with this today.
The
Off the
sound is,
entities are.
uh-oh. Can, can you hear me, Lauren?
I can. Can you hear me? I can
Okay,
hear
no,
you.
it's super choppy.
Okay, let me. It would want to get choppy when I start presenting, huh? All right, let me
It's
do
not,
this.
it's clear now, but when you had begun, it was really choppy, but it's clear now.
Let me switch my internet to a hotspot so that way it could be consistent for the presentation and not go.
Zooming now.
All right, guys, and we are back. Sorry about that, technical difficulties such as life. So we are picking up where we left off yesterday with the two overbranching entity types that I was telling you about, LLCs and corporations, and we were going to do some pros and cons between the difference of them. As we talked about yesterday, corporation is just the overarching branch and theme for it, but it breaks down into basically S corps, C corps, nonprofits, a benefit corporations, and a nonprofit private, which are usually just private foundations that way. So some of the pros and cons to this are the tax elections and the benefits, right? So we went over LLC kind of in depth yesterday, and that's the pro of a LLC is that it's going to be easy to set up. They're usually cheaper, and depending on the state, sometimes the maintenance of them is going to be a lot cheaper or not required at all, right? I gave an example yesterday of how in Arizona there is no annual requirement for an LLC, while in Illinois there is an annual requirement for an LLC. The fee for that annual filing requirement is cheaper than if you were doing a corporation. So those are some of the pros. Some of the cons are usually the structure for a LLC is that the members are all, for them to be a part of the LLC, and they have to be a named member. And so when you are doing your articles of incorporation, you are listing the people who are getting a percentage of that. Sometimes you might want to have silent partners, and that might look like them joining as a company, different variations, or sometimes they don't want to be listed at all. So that might be one of the cons when you get investors in. You don't want to give necessarily away a portion of your company in that way, in that format, where they're a part of the documentation, they're on record, on file, they have decision-making ability because of that. So one of the loopholes around that could be the formation of a corporation, right? Where you can have shareholders and stakeholders who technically are part of the company in decision-making skills based on the amount of shares that they have, which equal the amount of percentage that they have, right? But they are not a part of the articles of incorporation. They are not listed in there that way. And you can decide what voting power that they have. I talked about yesterday, but you can be more specific on what type of share they are getting, what type of stock is being issued, and that's more of an administrative duty that's handled, right? According to how you have it set up via bylaws, but you issue stocks and shares out to those people. They are not required to be a part of the initial articles of incorporation when setting that up, right? So that's one of the cons of an LLC and why you would consider a corporation. But we talked about it yesterday. One of the tax infrastructures of corporations can be a turn off. LLCs have the option of being taxed as an S corp, as I mentioned yesterday, but S corps, C corps, things of that nature, the tax benefits of them, the flow throughs of them, there are many workarounds if in working with an accountant that might be beneficial for you there. So a pro, it's a con for an LLC, but it is a pro for setting up a corporation is the exact thing. The ability to have the flexibility to have different types of members, have them be silent, have them have their issues of stock and shares, but it not really be something that is based on what the company has set up or established initially in the beginning, but something that they can handle on the back end and change from time to time as they decide and require, right? As they're issuing out the stock, right? You're going to get stock A, stock B, so on and so forth. I even mentioned yesterday how Google has several different stocks. Some of the stock is public, some of the stock is private, and some of it is reserved for just the initial founders and employees, the board of that team. So you have a lot of different options on how you want that to do. The con is really taxes, right? And really taxes, the maintenance fees of corporations, um, and not just maintenance for the state side, but maintenance and needing an accountant to do your records because the taxes are so complex, right? Needing to have a team of people to, check in legally. You have to do annual meetings required legally. Having a record recorder to make sure that that's kept somewhere and it's on file for the corporation. So maintenance overall can be a con of a corporation if you are a startup business or needing something to have in place overall. At the end of the day, this decision is going to come down to you, what type of business that you have, and what is the best decision for you and your business when you are getting set up, which is why yesterday I mentioned it's great to have an accountant and a legal advisor that you are consulting with to make sure that you guys are counting the cost of both now and future moves that you are trying to make and position yourself for as a business. Now, you can also convert your business, right? So there is no right or wrong thing. It just means you might have to redo some things and revisit some things later down the line. It might be a little bit of a headache, but you are never locked into an entity that you choose. It's going to take a little bit of elbow grease and room to move that around, but overall, the commitment is still there and you can shift as needed for this, okay? So we talked about the contracts yesterday, and I said I was going to revisit employee agreements and IC agreements, right? So these are going to be because once you're a little bit more established in your business, you want to have people join your team. These are people you're going to be working with, and we want to make sure that we're using these correctly. The first thing to start with is what's the difference between an employee and an IC? I think it's a sliding scale. This is governed and monitored by the federal laws, such as federal wages. That's where that kind of comes from. But they also have some laws in place because if you have an IC, you are not responsible for any of their taxes, workers' compensation, Social Security contributions. That is going to be solely the liability of that contractor, right? As an employee, you are responsible for that. State and federal taxes as well. It can be cumbersome when you have an employee because there's more involved that you have to invest in with them, right? And so a lot of people basically there's a huge incentive, right? It's very cost efficient to have ICs, but it's not always legal to have ICs if you aren't actually treating them like an IC. An IC basically they have their own business, they conduct their own business, and they are their own business. They do and come and go as they please. The more control that you have over an IC, the more the federal government is going to start looking at you and saying, maybe this is an employee that you're trying to categorize as an IC so that you don't have to pay all of the other required wages and contributions as if they were an employee, right? So as I mentioned, it's a sliding scale. You can go to the website, the federal government website, and they can list it out to you. There's no set right or wrong, but the more that you're checking off where you control what they wear, you're controlling what time they need to be in the office, you're controlling that they have to follow this handbook, right? The set of rules that you are presenting your client with. Not that any of these in and of themselves would like one or two of these automatically is going to consist of them being an IC or break them being an IC, but the more, these are just some of the examples that are on the list, and the more that you have of these being checked off, the more likely it's going to look like you have a lot of control over this person. They're actually your employee versus an independent contractor. And what the government will actually do is they will go back and look at your relationship with this person and how long that has been in play. And even if you have a contract with them as an IC, even if you have been paying them as an IC, if they file a complaint and say, actually, I've been treating like an employee, they investigate, they agree, they will go back and charge you all of the back wages that were owed as if this person was an employee. This is a very big decision that needs to be considered. You need to be aware of it. And it's something that the federal government is actually cracking down on because a lot of people are avoiding taxes. A lot of people are avoiding, workers' compensation, Social Security benefit contributions because they are miscategorizing employees as ICs and evading that tax record, right? So That's something to really be mindful of in the very beginning. What's the difference? What is it that I'm looking for? And let me just give you an example kind of what an IC is, right? This is going to be someone who's hired for a project base or a particular scope of work, right? So for instance, if I am a graphic designer and I'm hiring someone who's coming in and they're solely going to work on the edits of things that are happening, right? Um, Basically, I can give you a deadline and I can say the project is going to be due on this date. These are my specifications for it. I want to make sure it's within this, quality range. This is your level of experience. You can request all of those things, but basically you turn over the project to them and you might have some touch points with them, like on this day I want to do a check-in, things like that, but you don't get to say, hey, you need to work on this between 8 and 5 p.m. during the day. They can work on it at 2 a.m. in the morning if they want to, right? Because they work for themselves. You don't get to say you have to talk to the client at this day and time. You have to show up for the calls and present yourself as this way. You don't get to say any of that and control any of that because they are not your employee. You basically give them a project. You trust their skill set that they have held themselves out to you saying that they are capable of doing, and you allow them the space and the freedom to complete that project. Really, that's the end all be all, right? You can, do some touch-ins like I mentioned before, but if you aren't satisfied with the work, you can give them feedback. You can correct them, course correct. However, ultimately, it would be inappropriate and not proper for you um, to say I need it this way, this way, this way, this way, on this date at this time, during these hours, this, and this, right? That would not be qualifying them as an IC. So I know that's really general. That's kind of the rule. But if you are ever in question about what this looks like, make sure you are consulting with an HR professional and or a legal counselor who can help direct you in the sense of making sure you are hiring in an IC versus hiring an employee agreement. So that's the gist of it. Let's dive a little bit deeper into what each of these agreements look like and what their purpose is. Let's start with the IC agreement because that was our last example. But an IC agreement basically is going to outline that scope of work, right? It's going to outline the specifications that you want the work to include, right? If you have deadlines where you're going to want to do some check-in, like first draft is on this date, second draft, final draft, you can list that in there, right? If you, even in the IC agreement, you want to specifically list that there is no relationship being formed with their business and your business outside of coming together to do this particular piece of work. You want them to say that they are qualified for the work that they are holding themselves out for. They're not just signing up for something to get paid and then they're going to give you something that is unsatisfactory and you still be on the line to pay them for it, right? They are agreeing, I have the skill set to perform at the level that you are requesting I perform at, right? So that's a level of protection there for you as a business owner. Also in IC agreements, you talk about the intellectual property, right? You don't work for my firm. You are not an agent of my firm. And we are agreeing that this contract does not create that relationship, which also means that you don't get access to my information, right? Or my trademarks, right? My intellectual property. You don't get to get a claim of right from this work that you are creating. You are creating this work for my company, for my clients, for my business. We will own this work. This is our intellectual property that you are just coming on board to help us complete. That's usually the default. You can give them a limited license where they can use it for marketing. They can say that they worked on the project with you. You can even say, this is how we want that verbiage to do, to be put in there, because ultimately we're paying you to come on to complete this project for you. We are getting the clients. We are the ones getting the work. We own this and we can decide how much of that we want you to give. So it is pretty standard for people to give them a limited license for building their own portfolio, marketing it, but it has to be that you did this in conjunction with our business, our practice. It's not something you did solo, that you own, so on and so forth, right? Independent contractors should absolutely be coupled, as I mentioned yesterday, with an NDA, because when you are bringing them into your company, they're learning your processes, your systems. They're getting access to your client information, right? They're getting access to some of the details on how you complete projects, how you are doing your work. And that might be something that they can disclose to other people. A competitor of yours, go to another company and get hired on with them and say, hey, well, this is how they did it over there. And now your secrets are with another person. So you definitely want to have a non-disclosure agreement, confidentiality, so they cannot release that information, but you also want to have a non-compete. This is where this comes up the most, right? Where people come in, they're contracting with you, you have a huge agency, they're working on one element of it, and they are looking and they're like, I can do this better, actually. I can do all these other things. This is just my little area. I can run an agency. Let me take this. I have the general blueprint and the framework because you've shown me. I'm going to now take this and I'm going to create my own business and I'm going to shut up shop across the street from you. Or I'm going to try to poach some of your clients that I have access to now, right? And that's where that comes up at. So definitely make sure you're coupling the independent contractor agreement with an NDA, confidentiality agreement, as well as a non-compete agreement, right? So to that point, we want to move into an employee agreement. I came back to this last because this is really not a lot to talk about here. I really don't want you to have one, and I'm gonna explain why. I think all but one state is an at will employee state, which means that you can hire at will, you can fire and terminate at will. Creating in a contract where you agree to a specific term of time destroys this at will agreement. And so, despite you being at an at will state, now you are responsible for maintaining this agreement and contract with them. You cannot easily fire them when things happen and you've built up this record of the wrong that they've done, so you can protect yourself as you should do at will state. But basically, you're on the hook for the time of term that is in this employee agreements. They are common in some industries and some fields, and usually you see this in professional fields. People who have gone through specific training, people who are going to be higher acquired talent that is hard to replace in the event that life happens and they want to leave. You want to lock those people in because you went through a lot of training. It's not a lot of you on the market, especially if they're in a niche field. A lot of engineers will have employee agreements sometimes. Doctors will have employment agreements. Lawyers will have employment agreements. Professional fields where you are in a niche, you went through a particular training and you have a particular skill set that is beneficial and useful. We might be in the middle of a project. It's not that easy to go out and find a licensed attorney that specializes in patent law and medical malpractice with a background in medicine or something like that, right? Very, very, very niche field. We're going to contract you because we have work that we need for the next year. We don't want to lose you. We're willing to put up with you and everything that's going on with you. We're going to destroy at will because even if stuff is going bad, we need you to be committed to seeing that through, and we're going to be committed to working through that, whatever that looks like, right? Outside of those particular situations, I don't recommend you give an employee agreement. You give an offer letter, you give a handbook, you give them a scope of work, and you let them know this is what they're coming on board for. But you want the flexibility to, if things aren't working out, I can go out and hire another assistant. And, maybe some training is, it's a headache to train them or things like that. But I would rather invest in that than the headache of putting up with that person for another 9 months when I know it's not working out in that initial 3 months, right? So be very, very mindful of that. That's why I saved it for last. It's not much to talk about because when you do, it just outlines the scope of work, what they're going to be responsible for, what the pay is, the term of that, some of the things that you want them to be responsible for or not responsible for. Remember, in an employee agreement, you can tell them more specific things on not to do, what to do, because you are going to have control over that, right? So be mindful of that when you're moving on with that. So contract tips, we went over this yesterday, so I'm gonna skip over one because basically what I wanted to spend the majority of our time with today is the trademark process. And basically like what the process of filing a trademark is, what that looks like, and possibly maybe in another class come back and tell you guys what that actual process looks like. Step by step, an actual application, right? So we went over the meaning of this yesterday. And so this is the process for filing a trademark. I know it's just 4 bullet points, but we're going to talk about it in depth, and that's going to take up the bulk of our time today. So there are different types of applications that you can do for a trademark, actually. We're just going to talk about the general one today when you are filing a 1A application, which means it is in use, it is in commerce, you are using your mark, this is something that you want to protect, and it is already in play, right? So the first thing you need to start off with is a name and logo search. You're going to do this in multiple places, 2 primary places. And basically, like I said yesterday, you can, just to reiterate, you can trademark a business name, a business logo, a business slogan, a business hashtag, and or a color that is specific to your business and or field, right? And so with that being the case, you want to when it comes down to that, basically the name, the hashtag, and a color, they're going to be pretty primary searches like a name search, right? A logo, however, and I have my logo behind this slide here so you can kind of see, right, as a watermark. It's a very intricate logo, right? There's an A. It has different markings on it. It has a swerved line. It has an olive branch leaves going in one direction and going into another direction. Together, they make a circle. This is a very intricate, actually. I know it doesn't seem like that, and very intricate logo, because when I'm going into the database to search this logo, I actually have to break this logo down into multiple pieces, right? So I have to go and find the number. That's how we search out the logos, the number that correlates with the olive branches, what that represents, right? Get the letter, put that in there. I have to go out and find the number that correlates with a circle around a letter that's in there. I have to go and correlate the number that's with the letter that's in there, and the element of a swerved line. What's the number that correlates with that? Even the stamped feet, right? I have to correlate all of that and explain that and search that out in a logo for my particular category to make sure that this is actually going to be available. I know it seems like a lot, it seems crazy. But when you search a logo, there is so many moving pieces and parts to it. So it's actually a more complex application than would be if you were doing a name search, a hashtag, or a slogan. You just go, you type in what the name is, you type in what the slogan is, the hashtag, or the color in that category. And the color you have to be a little bit more specific with. You have to just define that and kind of pinpoint exactly what the color is going to be and what category it's used for. But generally, you type that in, it's going to come back and let you know what all is in the system for that. And then you go in and you look and you see if it correlates to the same category that you are trying to register with. The trademark office has over 45 categories that are registered. They are broadly mentioned. They're very general. So for instance, if you are in education, that's going to be a category. And then when you go in, you can describe specifically what you are educating people on, right? And so from there, once we do the search in the trademark system and it comes back good, that's the first search we want to do. We want to make sure that it's available. We want to make sure that it comes back. And once we know that, once we have that, then we move on to the market research. And why this is important is because if the trademark isn't available in the USPTO system, which stands for the United States Patent and Trademark Office, if it's not available in their system, we don't even want to waste our time looking for it otherwise, right? There are a few loopholes if it isn't available, but if I come back and do an in-depth application process, I'll talk about that then, because we'll do a search, we'll go through this entire process, and you'll see what happens if something doesn't come back. Let's do a little bit more research. We can delve deeper into that and see if we can, there's a loophole that allows us to still apply. But in general, let's say that it doesn't, or there's no conflict and it is available. We can now move on to that market research. If it's available in the trademark system, then, and it's not a guarantee either, there's a 48-hour to 72-hour lapse. Can't remember exact time frame right now. There's a lapse for it that makes it basically, the system isn't live. It's not a live search. So applications that have come in within that window prior to are not going to be showing up. So there is a slight chance, even if you file an application, you do a search, that you might get pushed back because of that reasoning right there. So with that being said, we want to now we want to do the market research. And the market research is important because even if it's available in the trademark system, if it is saturated in the market, right, we get protected on the trademark end. And now it's my responsibility to ensure my market is not being, no competitors are coming. It's backed by the trademark office, but I still am responsible for looking out to see if someone is infringing upon my copy or my trademark, right, my intellectual property rights. And if that is the case, I then need to go back to the trademark office and say, hey, this is the business that's doing that. I can send a cease and desist letter with their authority before. If that doesn't work, I can go to the trademark office and say, hey, I'm filing a suit. They're infringing upon my registered mark with you guys, right? But if it's market saturation, that's going to cost you a lot of money to even find them, to research that. It's going to cost you a lot of money to send out all those cease and desist. It's going to cost you a lot of money to go to the trademark office to do that. And so even if the mark is registered, to enforce that registration, you have to make sure it's not saturated in the market, because it's going to seem like an endless battle of protecting this brand. And ultimately, it then makes your registration over here worthless, right? The money that you spent to register the mark, to invest in it, it's not worth it anymore in the end. And so you want to be really, really mindful that both of those things are in play. Both are equally, if not more, I would say they're equally important. A lot of people put a weight on the USPTO database. They're like, and honestly, so there are some times where it's like 2 or 3 people who have it and they haven't registered. And I would encourage my client to say, hey, it's first right of claim. Go ahead, go and register that, and then we can send cease and desist letters and get them to shut down. But if there are 15 to 20 and endless people who are coming up when you do that market research, I have to have a conversation with my client. Even though this is available, the market demand for this is so cumbersome. You're going to spend a lot of your time, efforts, and money fighting to establish your brand. And that can be expensive. Do you want to go after all of these companies? This is what that might look like. Some of them might respond, some of them might respond.
Picking up
But these
again.
are all things that it is. Oh, okay,
Yeah,
let me make sure it's here. It is not. It
only
went
for
back
a couple
to,
of seconds.
okay.
Okay. All right, we're good.
Okay. So these searches are very important for that reason, because we want to make sure that we are protecting our business and our name, and we want to make sure that it is available in the market, and it's not going to potentially, these searches cancel each other out, right? So if it's not available, if it's available in the market, but it's not available in the UPTS, so you don't have a registration, you can't protect anything. If it's available here, but it's oversaturated over here, what good is this if it's going to cost you 10 times as much to go after that protected and to fight to establish that brand? So the searching process of this is very, very important. It has to be very thorough. And it really is about basically counting your costs, very similar to what we do in the entity setup stage. So that's the first step. The second step after that is going to be the application. Like I said, today we're talking about the 1A application, which is in-use commerce application. And with this, basically you input all the information that is going to be registered, right? So if you are doing the name, you've done a search for it, you insert the name you want to do it, you insert who you are registering this to. The cool part about this is we've already gone through that entity part. So you're established as an entity now. We can set up our entity, right? And so we set up our entity, we get that going. And then from there, the entity is in place. We can register and actually give some assets to our entity when we do our application. We can say, my company is going to own this trademark, actually. And that's what I recommend for my businesses that are established. Don't own this personally. You want your entity to own this. And so you can have some assets. So over time, if you want to sell things, as your brand is building, you can now sell that in the name of your company and get the value of your company back in there, right? In the application, you're going to need to show proof of use, right? You're saying I'm using this as in-commerce, because they don't want people sitting on ideas. They don't want it to be saturated with people registering for stuff. You can, that's what a 1B application is for, but it's a time limit to that. And you have to come back and show that you are showing use, right? So if you don't do that, the application will lapse and it goes away, right? So if you have a 1A, they require you to show that it actually is in use, so you can establish you're not just sitting on this brand in this market, right? You have to show actual proof of what the logo is, maybe some proof on a website is showing in market. And a lot of people get confused on this part. It's called a specimen. And basically you show the specimen of how it's in use in commerce. And it can be any of the ways that I mentioned, plus several different other types of use. But a lot of people get confused on this and they'll just send in their brand, right? If it's a t-shirt brand, they send in a copy of their t-shirt or the logo, and that doesn't show that it's in commerce, it's in use. It just shows that you produced it, right? So you have to be very specific around what they are looking for that proof of specimen. Also in the application, they often will ask you, to describe what trademark it is that you're doing, right? So this is a good time for us to revisit the name and the logo breakdown that I told. If you have a name and you're submitting, you need to submit a picture of the name that you're using. Usually it is going to be, actually, I'm sorry, once you type it in, it's going to produce a picture. It's black and white. If you are filing for a color use, of the name, that's a specific other box you need to check off. You need to do a description for that. So the application can be very detailed and very thorough depending on what type of application you're doing. As I mentioned before, if you're doing the logo, we had to go through and search and find each one of these numbers that correlated with it. This is where we're going to put that in on the application, right? We got to put in every single one of those numbers, the description that goes with that number. And we have to show and describe to them what the logo is. What is the mark doing? And usually they'll come back with a revised description for you on this, but you have to offer the initial description and as close to possible as what is going on. And then they'll take that and they'll like tweak it a little bit to fit exactly what it is that they're wanting it to say based off of their coding and descriptive codes. But with the logo, it's a lot more into it. You have to submit pictures of the logo. If you are doing a color claim and right to it as well, you have to submit that as well as the proof of use that was mentioned before in the name application. They're also going to ask you for the first time you use this in commerce, right? That does not have to be the date that you are applying. So a lot of people have been using their brand and their company long before they get to the trademarking process, right? Go back to the date that you first started your company and you were using that brand and that logo. That is going to be the first use of in commerce, the date of first use in commerce. And then they're also going to ask you, like, what was the day that you pulled all of this information? Usually it's the date of application, but if you did the research before, you're going to say, this is the date that I actually researched all of this information and I'm submitting it on this date, but I pulled it last week, whatever that date may be, right? And pretty much that's the application process. It's I'm really summarizing it and making it seem, very like smooth over, but it can be very detailed. It can be very thorough. To be honest with you, the user interface for it is not very user friendly. It's very dull. It's very like matter of factly click. It's not very robust at all. It is several pages. I think maybe 7 to 8 pages that you have to fill out. You have to go in, put in your category, search what it is that you're doing, then insert like your subcategories for that area and be very specific around describing what it is that your mark is going to be used for, right? But that's why partnering with an attorney for this process can be helpful, not required, of course, but if you do get tricked up along the way, make sure you just seek out legal counsel for that, okay? And our responses. So this is what happens after you submit your application. It kind of goes into the black abyss for a little while. You are just sitting and waiting for someone to get back to you and respond with your application and what's happening and what's going on, right? So you wait. The wait time varies. It changes. It gets updated from time to time. Right now, the current wait time is about 9 to 12 months before anyone even responds to you. And you are just waiting. You are waiting. Nothing is happening. There are no updates. There is nothing going on. They do give you a registration number when you file your application. So you can go in, you can check on that registration number. But if the registration number doesn't come through, or if you are, when you go, it's going to say live because as I mentioned yesterday, your application is good from the date that you filed it. It is live and you have protections because they're thinking once they approve it, it's going to be backdated to that date, right? So it's going to say live, but pending review, right? And so once they finally get it a review, there are several things that they can come back and they can say or request from you, right? So the first is which is there's an approval. Very, very unlikely that they come back the very first time and deny it. They usually might come back and ask for more information to clarify the reason that they should not deny it, right? So they'll tell you what their claims are for that. They might say it is likeliness of confusion. They might say that this mark belongs to someone else. Can you, like, do you own this mark? It's actually registered already. Can you describe that? Which happens with companies who have multiple marks sometimes, right? It's a logo that's already been used and they're like, okay, well, we actually own that logo too. That's an easy one. You just let them know, they submit it. It's all good. They might request, sometimes if you are doing like a personal name, they might request, so you should submit this in your initial application too, but if you forget, they might come back and request a letter of self. So basically saying that you have the authority and the right to register this name because you are the person who's registering it, basically. And those are, honestly, the likeliness of confusion is the biggest response that you're going to get. They will give you a 6-month time frame to respond to the letter, and it is a court proceeding. Let me say that. So the USPTO is a federal governmental office, right? They have federal authority from the government, and that's not right. So they are a federal agency that has legal authority from the government. And in the event that you do not meet these deadlines, very similar to a court hearing case, you face penalties where you will be fined, and or you face getting your mark completely abandoned, and you have to start all over with the process, right? So because of that, it is a very it's a very tedious process if you aren't familiar with it, right? When you get it and you have to respond, it's like, oh, I need to go and type up a response. I need to put something together. And in doing so, it can be time consuming, right? It can be something that is distracting, because you now need to go do research about this process, and you now need to go and put things together that you're not familiar with, and that's taken away from you and your business. It's taken away from you and your family and friends. It's taken away from you and your day-to-day life and your job, the day job that you might have, right? So responses is where things can get a little busy again, because you have to sit down and commit to responding within this time frame. And things move a little quicker then. So once you respond within this time frame, they're going to respond back to you. And once they respond back to you, things are good to go. They're going to give you another deadline and time frame. You have to respond again to that up until they say, this is the final hearing. This is the final letter. All of your explanations up until this point, we don't think that's strong enough to convince us or to establish what it is that we're trying to disprove. This is the final one. If you would like to reserve the right for an appeal, do so now, but you need to respond by this deadline, and you have to pay the fee for the appeal. You reserve the right to appeal. You pay that fee. It is non-refundable if you decide not to go with the appeal. If they decide to approve it at that point, you just reserve the right to get on the docket for the appeal. You lose your money out with that, right? But say, for instance, you go forth, these are the responses that are going to happen. They're going to respond and say, sorry, the mark is not approved. And if you didn't file for the appeal, that's the end of that process. You can start all over and try again, or you can just re-register with another mark, right? The second thing is they're going to come back and they're going to approve it. They're good to go. What happens then is that they let you know that it's being posted for opposition. So current trademark owners who own rights, the examining attorneys have an opportunity to review it to see if there's any conflicts. And then they allow people who are registered the right to say, hey, this is a mark we're going to approve. Do any of you guys feel like this is conflicting with your brand as well? They can respond to that and say, we do, we don't. And most of the time, it's going to go without opposition. And then they will send you a letter letting you know that it's being published in the Gazette. And they'll give you the date that it's coming out in the Gazette. And then at that time, once they publish that, they release out your actual certificate of trademark that they will put in the mail for you, right? If they don't approve it, but you have filed for an appeal, once they have submitted the final appeal, the final denial, that will get passed on to the appeal office, and then they will reach out to you to start the appeal process. And basically, very similar to the response time, but it's coming from a different the appeal agency, and they will communicate their deadlines for you in communicating, or for responding. They will let you know what their process is. And basically with the appeal, you can't introduce new information. It's based off of everything that you've already taken and submitted to the examining attorneys, which is why those responses are so important. You have to make your claim, and basically when you appeal it, you're appealing that they didn't make the right decision, right? That all the information that you provided was convincing enough, and it should have been good enough to get approved. And so you're not really putting your mark into appeal, right? You're putting the reasons that this person denied your mark into appeal. So essentially, you're putting the examining attorney under appeal and saying, hey, they missed it. They didn't do this right. We're appealing this because we want you to look at what they did and why they denied it, and agree with us that it should have been approved for the reasons that we told them it should have been approved for, right? That is the appeal process. Very rarely, depending on how long it can go on, they will introduce new facts, and or they will allow you to clarify something if they're confused on what the process was with the appeal attorney, or if they weren't clear on something that you responded with, they will allow you to provide that additional information. But generally, it's based off of what you've already submitted, and why that person was already denying it. So it's very limited, but that's why the response is going to be so important with that. So with that being said, I am going to, that concludes the breakdown of the trademark process, actually, with that. I've been talking about this for 15 minutes. I know it's a very dense subject, but if you guys have any questions, if you have any follow-ups, be sure always to contact Christina. She can follow up with you guys about this. And once again, here's my contact information if you guys want to get in touch with me. LinkedIn is also a good way, but you can visit my website. You can email me. If you call me, I don't typically respond or answer immediately just because of my schedule, but you can also text, things like that. And usually, what will happen from there is that I will provide you with the information to set up a consult. I don't do free consults. So if you call and you are giving me a lot of questions and things like that before, I will politely redirect you so you can set up a consult and get all the information and things like that set up that way. Same thing with the email. My assistant will see it and she'll say, Lauren's happy to answer your questions. Set up a consult. We can go from there, right? But with that being said, I did offer this yesterday. I didn't really talk about it or go through it, but basically a startup bundle pricing. It's a special way for me to help you guys with everything I talked about today. So entity setup, setting you guys up with some contract templates for all the contracts I went over today and more. Actually setting you guys up with a trademark as well and offering you a console. So a console will be included in this bundle if gotten. I do offer payment plans that comes at additional cost. And I do offer, if you pay upfront, you get a discount for that as well. So this is all the information regarding that. If you have questions about that as well, you can reach out to Christina or myself. And this offer is good, I would say, until mid-May of this year, 2022. I know some of you guys are probably watching the recording, but if you are still interested past that date, reach out to me. The pricing might be different, but I can probably still create another bundle to get you close to that pricing as well. But with that being said, I'm going to go back to my contact information and turn it back over to Christina. Thanks again for having me.
Thank you so much, Lauren. This was very, 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 very insightful. Taking a deeper dive into all of those different, very important components. Trademark is something that people always ask about, and you get different responses, So, but just to give people a better understanding of what it is all about, we appreciate you for that. And we're looking to bring Lauren in again, either next month or in June, to take a deeper dive into trademarks and what that application looks like. If you do choose to do it yourself, at least you can have a better understanding of what you are doing. So we appreciate you, Lauren. I will be sharing this recording with anybody who register for the event. And we will be back next week with another workshop, I believe the 25th, which is Wednesday or Tuesday, or maybe Monday. What's the 25th? Monday?
25th is
Yeah,
Monday.
the
It is.
25th. We have part two of Adrian's workshop series talking about Shopify and e-commerce, how to really utilize Shopify as an e-commerce platform for your businesses, taking your business offline to online. If you have things that can be sold through e-commerce and you're not utilizing the platform or any platform yet, this is a great opportunity to learn about a really good one. So we appreciate you all for tuning in. We will see you all next time. Goodbye.